Management is a business management consulting firm that specializes in helping CEOs protect their brand and use legal as an asset. We help them manage legal issues, and we have affiliations with several specialty groups, and one of those specialty groups is Fisher Phillips. And we have James Fessenden on with us today, who has a stellar track record in representing clients. And in labor matters, he has some really good, I was just commenting earlier that he has some great walkaways where his clients were able to walk away without any damages in some very significant and serious matters. So James, welcome. It's great to have you on with us today, and we'll go ahead and get started and go through the presentation.
Sure. Thank you very much. Glad to be here.
Okay.
All right. So one of the things I was explaining is that we're in, just to set the table and sort of provide a 10,000 foot overview of where we are. We're in what I'm calling the 10,000 or the fourth wave of employment litigation. And the first wave was the rise of the unions. That happened probably 80 to 100 years ago. And then first in California in the 1960s, and later at a federal level in the 1970s, the government started passing things related to Title VII that prohibited discrimination and retaliation and harassment. And then in the late 1990s, we had our third wave where class action litigation became really huge, and employers in California started getting hit with things like class actions over meal periods and rest breaks and things like that. And then our fourth wave, which is what we're starting to see the beginnings of now, is related to spreading liability across as many entities as possible. And the idea there is that the legislature does not like the idea that an employee could be cheated out of wages or overtime in theory and not have a deep pocket to go after, or at least have some pocket to go after. So there's a huge increase in legislation that is designed to bring on this legislation as much as possible and encapsulate as many employers as possible. Two ways this is happening. First is independent contractor classification. It's becoming really hard to treat employees, or anyone as an independent contractor. And the second is, at least in California and potentially some other states, there are laws that are imposing automatic joint liability. Now, for the most part, those laws are specific to certain states or specific industries. For instance, in California, if you hire a janitorial company, there's a bunch of special requirements you have to comply with. If you hire a security guard company, a construction company, a landscaping company, there's a bunch of specific laws you have to provide and you have to comply with in order to avoid automatic joint liability. So I do employment law, obviously, but I've become an expert in drafting janitorial contracts and security guard contracts precisely because of these laws. Yeah. And obviously our clients want to avoid imposition of automatic joint liability. So that's why we've got sort of at a 10,000 foot level, that's where we are. The most recent addition to this landscape is AB5 in California. This law is the one that in the media is being told that it targets the gig economy, and there's probably some truth to that, that it is attempting to target the gig economy. That doesn't mean that that is the only industry that it affects, and it certainly doesn't mean that it'll automatically create a problem for the gig economy, but it certainly is a roadblock for a lot of companies, both in and out of the gig economy. This law is, I think it's about 6,000 words long. If you put it into a Word document, it's 12 pages, single spaced. It's very dense. And there's a lot of weird legalese and legal jargon. And the reason for that is there was a ton of last minute exceptions made and exemptions made, depending on how good an industry's lobbyist was. And that's why it's so dense and lengthy. But that said, this law does three things that we can boil this law down to. First is that it creates a more stringent legal standard for who can be classified as an independent contractor. Second is that it throws in a bunch of narrow exemptions. And then the third issue is that it applies the same heightened business standard to business-to-business relationships, or at least it arguably does. The effect of that is somewhat debatable, and I'll get to that in a little bit here. So let's roll through why the new test for independent contractors is a big deal. The reason for that is for the last 80 years or so, we've had various tests based on control. And there was different ways these tests were articulated. The IRS has a 21 factor test. The Department of Labor had an 8-factor test. The state of California had a test. Everyone had their own test. And they all had these different factors. But really, at the end of the day, it all came down to how much control did the hiring entity have over the contractor. And this allowed us to do a certain amount of arguing, to be honest. There's some ambiguity in the law. And of course, we use that to our advantage, as did everyone else. And we would say, well, we didn't really directly oversee the contractor. The contractor had some special skill that we didn't have. They supplied their own equipment, plus that we had this lawyer write this vendor agreement. Therefore, they're an independent contractor. And that's kind of what we were able to do under that old control-based test. That's not going to be the case anymore here, unfortunately. My next slide. What we've got now was, starting last year, was the introduction of the ABC test. It's actually not new under AB5. Our Supreme Court first articulated the ABC test, which is what this new test is called, last year in the Dynamex ruling. It wasn't clear that that case would go beyond the facts of that case, and there were some arguments that maybe the legislature might turn it over or might pare it down. And instead, the legislature adopted the ABC test in full and actually did a little bit more than that and made it a lot more applicable. So now what this ABC test is that a person or an entity that retains an independent contractor has to prove all of these 3 elements. First one is control, which is basically a variation of the same control test that's always been the case for independent contractors. So that part's nothing new. That's just the same question. Is the hiring entity exercising too much control over the independent contractor? Next one is we have to show that the contractor is performing work outside of our usual course of business. So if they're doing stuff that's in our business's usual course of business, that won't work. And the third is that they have to be working in an established trade or a business. And the exact contours of what is an established trade or business is somewhat vague and unclear. But if you put things at an extreme, it's going to be harder to argue that an agricultural worker who's picking, fruits or vegetables is an established trade or business. And at the other end of the spectrum, probably easier to argue that a neurosurgeon or your IT technician or your plumber, those are all established trades, right? So that's going to be a little bit easier. The biggest issue, of course, is B. This is what's new, and this is what is the most controversial, meaning that the contractor has to perform work outside of the usual course of business. And this is also why, rightly or wrongly, this is viewed as an attack on the gig economy. Because most gig economy businesses, they are a software-based business, but they hire contractors. They put contractors in touch with customers, and the argument is that those contractors are doing work in the usual course of business of those technology platforms. So who might be misclassified under this new ABC test? It's hard to say. It's highly situational. It's going to depend on a lot of facts, which doesn't make anything any easier. There's a lot less black and white to this, unfortunately. But there are a few black and white rules I think you can draw from the ABC test. First is, I think anyone who's doing the same work as any of your employees as a contractor is almost certainly going to be misclassified. Probably anyone doing anything your employees used to do or could do is probably also misclassified. And again, I'm oversimplifying it to an extent, because this entire analysis is always going to be highly situational. But I do think those are 3 basic rules you can live with. There's a few obvious problems. CFOs, especially if they're not a CPA, it's going to be harder to treat them as independent contractors. IT folks is going to become increasingly difficult. If you're a smaller company and you hire an actual vendor that comes in and provides IT every once in a while, I think that's probably going to be okay. But to have any sort of full-time or quasi-full-time IT staff on your contractor, that as contractor status, that's going to be difficult. Also, anyone in sales or production, I think, is going to be very difficult to treat as an independent contractor. I think that this term usual course of business, it's not been litigated much. There's no court decisions on it. There's a lot to work on, but I think it's also going to be opened up to a lot of ambiguity. And I think there's going to be some level of interest in measuring the size of the business. So what I mean by that is the usual course of business for a small employee that has 4 employees, or maybe a cafe or a deli or a small restaurant is going to be different in terms of what can be covered than a much bigger restaurant chain, right? For instance, if you have a deli that has 4 or 5 employees, I think you could argue that they shouldn't have to have an IT employee as a full-time employee. But a big international restaurant chain, they're going to say, look, of course you have to have an IT department. And that is part of your usual course of business because you're a big company, you're international, you've got 4,000 employees, you make $2 billion in revenue. For you, an IT person is within your usual course of business. So I think the size of the company matters, the resources of the company matters, and what business they're in is all going to matter too. Just to make everyone's life a little bit more difficult and make this more complicated, AB5 will be retroactive when it goes into effect, which is January 1 of 2020. So at that point, it will have retroactive effect, which is astounding. I'm betting that some of you are wondering what happens if I just tell my independent contractor to create an LLC or create an Inc. Do I automatically get out of this? And the answer is a resounding maybe. Does it help? I think it does. I think if your contractor has an LLC, I think that's probably helpful. I don't think it's automatically going to save you, and there's 2 reasons for that. The first is that we have this somewhat goofy provision in the California Labor Code where they define the word person, and person can mean a limited liability company or a corporation. And then if you go back to the ABC test that was codified in AB5, they made it the person. They could have said the worker. They didn't. They said the person. And I don't know that this is what they intended to do. I don't know that it's a great argument, but it does give me some level of pause that they use the word person here on the ABC test, and person can include any company. Second, Second issue is that we've got this business to business section of AB5. So there's a whole nother provision within AB5 that purports to affect business to business relationships. And what it basically says is that if there's a contracting entity, meaning the hiring company hires a vendor, and we can't satisfy 12 factors, then it doesn't mean those employees of the vendor are automatically your employees. That is not what it means. What it does arguably mean is that the ABC test will be applied to the vendor's employees to see if they can be deemed as employees of the hiring entity. And that's a fairly astounding law to put into place here, but it is what they put in. It's also very vague. It's not clear this is what they really intended to do. The author of the bill had to write a letter clarifying this section, and it was actually attached to the bill, meaning it's part of the legislative record. It's not part of the statute, but it is part of the legislative record at this point. And it says that it's not the intention to focus on joint employment issues as much as it is misclassification, which is great, but this statutory language is still in here. So it's worth being at least familiar with what the business to business requirements are. So here's how this works. If you are a contracting entity and you hire a quote unquote business service provider, that's what they call the vendor, we have to be able to satisfy 12 factors. And some of these are a lot more controversial than the others. First is they have to be free from control. That's sort of your basic analysis there. Then they have to be, this is one that is controversial for certain industries. They have to provide services directly to the contracting entity, not to its customers. And for some industries, that's a big deal. They have to have all the required licenses, which seems manageable. They have to have a separate business location, meaning their location for their LLC can't be your business location. They have to have their own separate address. And I don't think that can be the residential address. There's some, I won't bore you with the details on that, but I don't think it can be a residential address as their separate business location. They have to be customarily engaged in the same work of whatever they're performing, meaning you can't have someone who creates an LLC and then does all kinds of work and just funnels it all under that one LLC. The work they do has to be related to what they usually do. They have to actually have other clients, which is a big issue for some of these folks. Doesn't mean that it's not enough for them to just be able to, or we put in our contract that they're not prohibited from working for other clients. They have to actually have other clients. They also have to actually advertise their businesses and their services to others and to the public. They have to provide their own tools and vehicles and equipment, which is fairly similar to what we always would have recommended for a separate vendor anyway. They have to be able to negotiate and set their own rates. What that realistically means here is that I don't think you can put a pre-printed form that says this is what we pay all of our contractors, now sign it. I don't think that's going to work anymore. I think there has to be some level of legitimate arm's length negotiation. The statute also says the business to business has to be able to set its own hours and location, quote, consistent with the nature of the work. I think that means that if you need a plumber to come to your house, obviously they need to come to your house. So they can't do that at home, and you probably need that more urgently. So the hours that you can demand are based on the nature of the situation and what you're hiring them for. The contract has to be in writing, and they can't do the kind of work that requires a contractor's license. There are a ton of exemptions from this. There's about 40 exemptions, and I wanted to highlight the main ones rather than try to go through them all. But here are your big pictures on the exemptions. A lot of my personal favorite of the various exemptions is commercial fishermen, but also there's some other ones that seem to just be thrown in there, like estheticians and construction truck drivers. But here are some of the more commonly commented on ones. First is people that would typically fall under the professional exemption, meaning licensed doctors, licensed lawyers, engineers, CPAs, they're exempted from this law. That doesn't mean that they're automatically okay to be an independent contractor, by the way. What that means is that the ABC test we talked about doesn't apply. But if you still exercise too much control over them, that's the test that would apply even to these folks. But realistically, doctors, lawyers, engineers, CPAs are probably going to be okay as independent contractors. And then they've got this other category that covers, quote, other professional services. And this was intended to cover HR professionals, marketing folks, possibly IT folks, maybe people who write for a living. There's an asterisk here for that requirement. Those even other professionals have to satisfy a bunch of other requirements. They have to maintain a separate business location. They also have to have a separate business license. Now, going back to the separate business location, I actually think that can be a residence for just these folks who are under the quote unquote other professional services umbrella. I think they can have their own separate business address be their residence. I just don't think the business to business allows for that. They have to be licensed if they need a license. They have to be able to set their own rates and their own hours. They have to perform work for other clients, or at least offer to. It's not necessary that they actually have other clients. For this area, they have to be able to actually have other clients. And then they have to exercise independent discretion and judgment. What that realistically means, that fifth requirement there, is that they are performing exempt level work and not rote work. This is intended to mainly focus on AB5, but I did want to touch on a few of the other requirements that are here in California that cause joint employment problems. We've got Labor Code Section 2810.3. That applies when there's a quote unquote client employer, meaning the big company that has 25 or more employees, and they hire a vendor to perform work. And you can see that usual course of business language is back in there. If they hire a vendor and they're not subject to one of the exemptions that's in the statute, they could be equally liable for unpaid wages and for workers' compensation for the vendor's employees. A few strategic recommendations here. I think it's important to know what your usual course of business is. And I do think it's appropriate to account for small companies versus big companies, and understanding that smaller companies' usual course of business may not be the same as a company in the same industry that's much larger. I'd also run a 1099 report, and then I'd throw those into one of three buckets. So each 1099, you want to know, are you paying an individual? Are you paying an LLC? Or are you paying a smaller vendor? And obviously the individual 1099s are my biggest concern here. One person LLCs are probably the second most urgent, and then your smaller vendors are probably the next category of folks you need to worry about. So with that, that's sort of a very high level 30,000 foot overview of AB5. It's unfortunately much more detailed and covers a lot more ground than just that, but those are sort of the big picture issues. And I'm happy to help with any questions I can.
Okay, great. Thank you. Really appreciate that, Jim. I am going to bring this back up on the screen. We have 11 participants, and they can unmute. I'll unmute everybody right now, and so people can ask questions. I have a question to start out with, though. What about a multi-level marketing company? A multi-level marketing company that's selling nutritional products, all around the world. In California, let's say they're a big company with 500 employees or whatever, or not employees. They probably have about 70 employees and 5,000 or 6,000 independent contractors. Is there an exception for them? Or are they going to have to look at making these people employees in California?
Well, they did exempt marketing professionals from the ABC test. So I think there's actually I hate to sound like a lawyer here and tell you that it's situational and that it depends, because that's not a very helpful answer. But unfortunately, the way this law is written, there's so many fact-specific inquiries here that I think it's hard to give a one-size-fits-all answer. But that being said, it would seem to me that some of these folks could fit into the marketing professional exemption, and they might be free and clear.
Okay, great. Do we have any other questions? Arlene? Go ahead, Arlene.
Okay, are you hearing me?
Yes.
Okay, so you mentioned that in the exemption list are random categories like estheticians. Does it also include cosmetologists or hairstylists?
I believe it does. I'm pretty confident it does include hairstylists.
Okay.
And to be honest, I can't remember off the top of my head whether cosmetologists are separately included. I can find out for you and email you though. There's like I said, I think there's 40 exemptions, and I'd love to tell you I have them all memorized. I'm not quite there yet. I probably will in another month or so. But estheticians are exempt. I'm virtually certain that hairstylists are, and I think cosmetologists are as well. And I can confirm that for you.
Okay, thank you.
Of course.
Great. Any other questions? What about salespeople? Let's say that you've got some salespeople that you have a product, you're selling advertising, you're selling some sort of service, and you have an independent contractor agreement with a sales guy in Pennsylvania or in this case in San Francisco, and that salesperson is going out selling your product in the ordinary course of business. What about him?
Yeah, I will tell you, that's a very common question, and a lot of people want there to be a different answer. But boy, if their job is sales and they're selling your product, I just don't know how you say that's not in your usual course of business. I mean, almost every business thrives on sales, and if you have a salesperson, then by definition, you need them to sell. And I just don't know how you get around that the person selling your product is part of the usual course of business. Now, there is one piece of good news there. First, if it's more marketing that they're doing, that may be exempt. And secondly, if they're truly sales and they're an outside salesperson, that's probably the most powerful exemption you can actually get under the law. So classifying someone as an outside salesperson, if they truly are an outside salesperson, and in California, that means that they spend more than 50% of their time going on sales calls, interacting with customers outside of the office, outside of their home office. And if they really are doing those kinds of things more than 50% of their time, I actually think that's a great status, because they're almost completely exempt from the wage order, from minimum wage in most cases. So I think the outside sales exemption is actually not a terrible thing to be in.
Okay, great. Terry, did you want to ask something?
I think he actually answered it. But my question was, what if they're working for a marketing company, they're selling our services, but they have other products or other things that they also sell.
Right.
So they're doing a couple different things.
And that is exactly why the outside sales exemption is exempt from the wage orders and exempt from minimum wage. I'm not sure that a pure salesperson gets out of AB5. I think they get out of minimum wage. I think that you get them out of most of the requirements under the labor code. but I just don't see how you get them out of AB5 if they're purely doing sales. Now, if they're doing marketing, that's where you might have some room. But if they're purely doing sales, I just don't know how you get out from under AB5 in the usual course of business prong.
So what would be the implications? So they're an employee, but they're an employee that are exempt from some of the other requirements of the labor code, right?
Right. Yeah, you don't have to pay them a minimum wage. You don't have to worry about meal break, rest requirements, meal period, rest break requirements. You don't have to worry about overtime. It's almost a complete exemption from the labor code as an outside salesperson. What it really includes and what's really covered, of course, and what's all important to the government is, of course, capturing payroll taxes. That's what you still have to do with outside sales folks. You've got to pay payroll taxes, and they have to have wages deducted from with taxes and withholdings. So that is the one catch. But other than that, they're almost completely exempt from the labor code.
Great. Okay, so that's important though, that they are employees and you do have to capture their workers' compensation, et cetera.
Correct.
Great. Well, it looks like we don't have any other questions, but thank you so much, Jim, for taking time today. I know you have a busy day and a busy schedule today, and we really appreciate you taking time to go through this with us, and hopefully we'll be able to talk with you about other issues in future webinars.
Absolutely. Thanks so much for having me. I really appreciate it.
Okay. Thank you very much. Okay. Bye.